Hi, good afternoon everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly community conference call. We do one every other Thursday, and typically people post their questions online. I'm not going to have time for new questions because we have enough to discuss. Already posted questions are online. So I'll do my best to answer as many questions as we can. I think I'll be able to cover everything that's posted. Let's begin. The first part, I will deal with the frequently asked questions. In my view, these are questions that get asked quite a lot. So I have marked them separately. First, I will go over them, then I will go over the regular questions. From Matt 9999, evidence or documents created after filing of a petition. This is something important to remember. As a general rule, USCIS takes the position that any documents or events that occur after you have filed a case are normally not going to be accepted as part of the case. So to give you an example, in the context of, let's say for example, an EB1, extraordinary ability alien, let's say that I have filed my case and then I received a huge award. Maybe I got nominated for the Nobel Peace Prize. Can I introduce that into evidence? The answer is probably not. Government can take the position that, well, you have already filed the petition, withdraw the petition and refile it if you want us to consider this evidence. So the general rule is they will not accept any evidence or documents that are created after the filing of the case, unless of course they pertain to things that were already happening before the case, which is a little bit of a legal distinction. We can talk about that some other time. That's not relevant right now. That's the general rule. So for instance, if I file the H1 and then I file an LCA to cover the H1, they won't accept it, which is sort of the case which is here for Matt. He says, I had my H1B approved in Feb 2017. Then moved to USA after the petition is submitted. My employer filed for change of status from H4 to H1 through premium processing in March 2017. Got an RFE on change of status for proffered position employer-employee relationship. Now there's a second RFE. They want to know, why are you making this a level 1 wage designation? See, I've been advising all our corporate clients to be careful. They should not lightly designate jobs as level 1 for H1B because, see, level 1 jobs are trainee jobs. They're not really, they're professional positions, but the person is still being trained. So typically somebody is right out of school, you're not going to have them start doing enterprise resource planning. You're probably going to start them off with some programming assignments, some systems analysis, some coding, testing, those sorts of things. You won't directly go into high-level design of systems or become a subject matter expert. So entry-level jobs that are still being developed, learning, those are the jobs that are level 1 jobs. So he's got an RFE that says, why are you a level 1? Then show us the documentation to support that this is a level 1. And submit a new LCA with a different wage designation. That's not going to work. This is a trick. If you submit a new LCA and say this is a level 2 position and the LCA is dated after the filing of this case, that case will be thrown out. You'll have to refile the case. So it doesn't work like that. They won't accept that. His questions are, can I get more information on point 3? I already discussed that. What are the possible documents employer need? No, that's up to your lawyer. I can't help you there. What are the other options if my change of status is denied? Well, if you're not subject to the quota, I don't know. You had an H1B approved in Feb 2017. So I'm assuming that you are not subject to the quota. You can always refile the case. You can withdraw this case and refile it. Am I eligible for transfer if I get an offer from a new company? Yes, if you have earlier received a change of status or an H1 visa. USCIS has been consistently telling us, let me rephrase that, inconsistently telling us that they want us to either get a change of status or an H1 visa stamping. Mere approval is not enough. Is my approved H1B still valid and cap exempt, whatever the outcome? And the answer is yes, if you have earlier received a change of status or an H1B visa stamping. Any follow-up questions on this, guys? Press *5. No new questions. Any follow-up questions? Press *5. I hope you can hear me. Let me just make sure. Oh yeah, you can hear me. Okay, this is a question from Virginia. Virginia, go ahead, please.
Yeah. When you were asking about the last question, my visa is approved and I'm cap exempt, right? And you said like I can reapply for a visa. Can you just
Okay, let me try to understand your situation. So you got your H1 approval in Feb 2017, right?
Yes.
Now, did you go and get your H1 visa stamping? Were you outside USA when you got the visa approval, the H1 approval?
No, I was in US.
And you got the change of status?
No, I don't have the changes.
So that's the problem.
Visa was applied.
That's the problem.
My visa was up.
Right.
Okay.
You never received a change of status to H1, and you of course don't have an approval, or, I'm sorry, an H1 visa stamping, correct?
Yes.
In those cases, government takes the position that you're still subject to the quota. But I'll tell you something, they have been inconsistent. I think they are legally incorrect. That does not appear to be the intent of the statute or the regulations. If I were you, I would still try to have another employer, if they are willing, to apply for your H1 and claim that you are quota exempt. There's no longer a quota issue because your H1 was approved. What if your change of status was not approved? What if your visa stamping was not done? That is not a part of the requirements. So you can argue that. Okay?
Thank you.
You're welcome. Good luck. Oh, what did I do? Not sure what did I do. This control is different. I'm a little. Let me just make sure you guys can hear me. I'm nervous about that because this control is completely new and we've had some issues with it.
The conference is now in conversation mode.
You guys can all hear me okay, right? No problem there?
Yes.
Okay, excellent. Excellent.
Yes.
Yeah,
The conference is now in presentation mode.
Let's go on to the next frequently asked question. So this one is a little interesting in the sense that this is not really clear, but I think that's the way the government is going, or so they have indicated. H4 EAD when an I-140 is revoked after 180 days. Well, we know under the new regulations, if your I-140 is approved and stays approved for 140 days, thereafter, even if the employer revokes the I-140, you have the right to keep extending your H1 beyond 6 years with any employer. Now the interesting question is, what about my spouse's H4 EAD? Because the H4 EAD regulations suggest that you've got to have an approved I-140 in play. If the I-140 has been revoked, then the H4 holder cannot get an EAD extension. Government has said that the new regulations, the benefit that extends to the primary applicant, which is you can keep getting your H1 extension, we will extend the same benefit to the H4 EAD holder. So in other words, if your I-140 was approved and it stayed approved for 180 days, thereafter, even if it is revoked, your wife or your husband has the right to keep extending their H4 EAD even though there is no I-140 currently in play. That's what the government said. So the next, I actually merged two questions here. One was from Chandra 25, which I just answered. He wanted some clarification. Then there was a post from Ram. He says, I got my I-140 approved in Feb 2016, more than 180 days. She got her H4 EAD. I'm planning to take a new job with another employer, say company 2. If my current employer withdraws my I-140, what about my wife's H4 EAD? Yeah, she'll keep it, and she can also extend it because your I-140 stayed alive unrevoked for 180 days. The only thing that can kill the I-140 dead is if it was approved by the USCIS in error, or if there is fraud or misrepresentation. These things are long shots, they can happen, but typically they don't happen. 2, by 2019, if I have to renew my wife's H4 EAD, do I need to have an approved I-140? Again, I answered your question. I think that takes care of it. Yeah, you can renew your wife's H4 EAD based upon a withdrawn I-140 as long as it was withdrawn 180 days after approval. Star 5 on your phone, please, if you have a follow-up question. Star 5. Press star 5 on your phone. Okay, no follow-up question. Let's go on to the next frequently asked question. Can a green card be started on F1 status? We've discussed this before many times, but I'll revisit it because it's important enough. You see, for people who are born in backed up countries where the priority dates are extremely backed up, like India, China, Philippines, Mexico, it's very dangerous to start a green card if your priority dates are so backed up and you're on F1 status, because F1 status does not allow us to have immigrant intent. Whereas statuses like H1, H4, L1, L2, O1, etc. allow me to have a dual intent. TN, for example, doesn't allow me to have a dual intent. So when you are in these kind of statuses where dual intent is not permitted, you file a green card, you run the risk of having trouble in getting any kinds of extensions, visa stamping, or re-entry into the US after travel if you are trying to use a non-immigrant visa requiring non-immigrant intent. So, but if you are born in a country, let's say you are born in Saudi Arabia or Pakistan or Nepal or anywhere in Europe where these dates are not backed up, then sometimes it is possible to get the whole green card wrapped up in EB2, EB3, EB1 category within a year, so that it is not that big a deal. It is possible to file a green card while you're still on F1. So if you're in a backed up country, from a backed up country, it's a lot more difficult. So the second question is, what if my spouse comes on F2 visa? Can she start a green card? The answer is the same. F2, F1 have the same problem. Once you go on to H1, then because H1 is a dual intent visa, H4 is a dual intent visa, you should not have any problems. Star 5 if you have a follow-up question, guys. Star 5, any follow-up questions on this? Okay, let's go on to the next frequently asked question. We are going to deal with new regulations, their effect on layoff after I-140 approval. Okay, let's see what the question is. I have I-140 approved. This is from Imi Kumar to 2017. I have I-140 approved and it is more than 6 months over. Priority date is March 2011 under EB2. If my employer lays me off, what immediate steps do I need to do in order to legally stay in the United States? Well, first of all, having an I-140 approval and an approval that stayed in existence for 180 days does not protect your current status by itself. So you've got to either, with the new rule, you've got that 60-day grace period to file for an H1 or any other kind of change of status after the layoff. So you've got that 60-day grace period. You could try applying for a tourist visa if nothing else works out. And on my blog, there are several entries. In the frequently asked questions, there are several entries. Go to immigration.com, look it up. And if you still don't understand it, come back to me and we'll talk about it in the next conference call. We have one every 2 weeks anyway. So By itself, the I-140 is not going to help you, but it can help you apply for extensions beyond 6 years with any employer because your I-140 was approved. With the new I-140 EAD regulations, am I eligible to apply for EAD using compelling circumstances? Yes, you can use compelling circumstances EAD. And if you go to immigration.com and you go to my blog, I'll show you where it is. So I'm going to immigration.com, and right hand side you'll see Rajiv's blogs. Just go read more, and there is, here it is, I-140 EAD regulations effective 17th January 2017. You click on that and you see a graphic which contains all the information that you need to know. For example, this is the compelling circumstances EAD information. Who can apply? E3, H1B, H1B1, L1 or O1. You can apply either while you're still on H1 or within 60 days following the H1 for compelling circumstances EAD. And then it tells you what are the various grounds. And I think I've made fairly good notes. Examples of compelling circumstances: serious illness or disability of worker or dependent. For example, it requires moving for medical treatment or change in working hours. Employer retaliation: they are harassing you and you had to quit, you had no choice. Other significant harm to worker, for example, financial harm. Your expertise cannot be used in home country. For example, I had this situation one time. I don't know what the situation in Pakistan is right now, but we had a satellite engineer from Pakistan who was working here in USA, and if he were to be fired and he went back to Pakistan, there's no job for a satellite engineer because they don't have a satellite program. That's an example. RF engineers were having a hard time finding jobs. So some of these, significant disruption to the employer is another example. There's even something like negative effect on home ownership. Actually, home ownership, negative effect on derivatives, entrepreneurship, etc. These are some of the reasons you can get. I do very strongly encourage you to go look this up. This graphic that I'm just scrolling on my screen from my blogs. I did a lot of work on this. There's a couple of small typos, but it doesn't affect the information. I think it's very, very good. I use it all the time to refresh my memory about what the law is. So go read up on it. Compelling circumstances EAD is certainly possible if you fit into any of those categories. Okay, so going back to all right, I think I covered everything that you asked me. If you have any follow-up questions on this, press *5, please. Any follow-up questions? *5? No? Okay. Let's go on to the next frequently asked question. This is about re-entry permit to preserve green card and extensions. Was it day before? No, yesterday. I think yesterday, or was it the last week? In the radio show that I do, there was a discussion about how you can lose your green card. And I told people, I said, look, you can lose your green card even if you leave USA for 1 day with the intention not to come back. You can preserve your green card if you have your permanent home in the USA and you leave for a short duration of time. If something unexpected happens and you just cannot return, there may be an argument to get the green card back, but it's got to be a very, very good reason. The other option is to apply for re-entry permit. Re-entry permit says, look, I came to the USA, I established my permanent home here, but I've got to go away back home for X number of years, not more than 2. For instance, I have a contract. I had a client who had a contract to teach in the Middle East, a college professor. They had a sabbatical for 2 years, went to the Middle East to teach. That's a very good example. Another example is you're closing down your business or you're selling real estate. That's a good way to do it. You can usually get 1 or 2 extensions if you have a good reason. But government does have the right to drop down from 2 years to 1 year extensions. And of course, they can take away your green card. If it's a family-based green card, relatively easy to get, for example, parents of a US citizen, we don't really care. If it goes, it goes. You can always reapply. Losing a green card or getting a green card taken away is not by itself any ground for any impediment to the future green card. I hope this is clear. I've thrown a lot of information out at you. This is discussed several times in many frequently asked questions, also in my blog at immigration.com. So this Parul says, I am a naturalized US citizen through marriage. Sponsored my brother and mother, but now I want to sponsor my father. He's not been able to get a tourist visa, so I don't know what to do. I think it's okay, Parul. Why don't you get him his green card and then do a re-entry permit if you feel that's appropriate. And if he loses his green card, then he loses his green card. That's okay. You can always reapply it again. But by the way, I tweeted something about Trump's new plan. Trump is going to support a plan whereunder family immigration is going to be reduced. Of course, that is not law yet. I'm just sharing with you what I found out. They are going to reduce low-skilled immigration and put more emphasis on merit-based, high-skilled immigration, extraordinary researchers, etc. In addition to that, they are going to cut down overall legal immigration by 50%. So I would not want to wait too long for family-based cases or other cases where a green card needs to be filed. When a green card is already in the process, it cannot be lightly taken away. It's very difficult to divest somebody's rights once they have already vested. So if you have something to file, please go ahead and file it. Don't wait up on it. The writing on the wall is dim. Unless Trump ends up going to prison before he's able to do anything major or do any major damage to immigration. He's done a lot of damage to other areas of the law. Of course, I don't want to talk politics. Everybody has a different opinion about things. But from an immigration perspective, things might be changing and not for the better. *5 if you have a follow-up question. Parul, I hope you're here. *5 if you have a follow-up question. *5. Okay, there we go. From my neighborhood in Virginia. Go ahead, Parul. Parul? Hello? Hello?
Hello?
Yes, I can hear you, ma'am.
Okay, fine. So thanks, Ajit. You have already answered most of my concerns, but
Right.
I have just one concern that you mentioned about the extension, that it has to be a really solid reason in order to get the re-entry permit.
I'll give you an example, Parulji. I'll give you an example. Well, first of all, when I do any government filings, I am meticulously truthful. I don't play any games. If you feel that your father is 7 years away from actually moving here, I think it's a little early to file, but at least you can get the green card rolling. Once he gets his green card, he can come visit. Somewhere along the line, if you decide you want to do a re-entry permit for him, make sure that at least the anticipated time is about 2 years. After that, if the situation develops, it requires more time. When you file the case, you can make it clear that we anticipate it to be completed within 2 years, his need to be away, but it might take a little longer. Then we will respectfully request more time. Only problem is he's got to be in the United States when he applies for it. Okay, so let's say he gets his green card, he comes here, then he applies for his re-entry permit. 4 or 5 weeks later, he does his biometrics, he leaves. You can send the re-entry permit once approved to him by FedEx, or he can pick it up at the consulate in India. So now he's okay not to come for 2 years. Then just a few days before 2 years, he can come back, apply for an extension if he needs to, and repeat the same process. Does that make sense?
Yes.
So,
Thanks.
yeah, that's the way it will work. Okay. You have a question? Go ahead.
No, I'm good. Thank you.
You're welcome, Parulji. Good luck. Okay, let's go back to the next frequently asked question. And this is also a very common problem. You enter the United States and all of a sudden you're given an I-94 which is of a duration less than your anticipated entry should be. For example, let's say you have an H1 approved till 2019, but when you entered, they gave you an H1 I-94 only till 2018. There can be many reasons for that. One of them is an error. And if it is an error, you can actually go back to the Customs and Border Protection, to any of their offices, explain the reasons, check with your lawyers, make sure it's their error, and they will correct your I-94. That's the easy thing. Sometimes they give you a lesser duration if your passport is expiring. If your passport is expiring, if it is only less than 6 months, they can refuse you entry. But if you are a citizen of India, we have a treaty with the government, they let you enter, but they might give you an I-94 which is for a shorter duration. In that case, you have two options. If you have a visa stamp and your passport has been renewed, you can go outside USA even for a short trip like a road trip to Mexico or Canada and come back. And when you come back, you get a new I-94. Ask for a new I-94. They will be able to give you an I-94 coextensive with your stay. The second option, of course, is to apply for an extension. But remember, H1 refiling, extension, H1 new filing, H1 transfer, amendment, they are all the same case. There might be some differences in the fees, but government reopens the case, looks at it all over again. So keep this in mind. Going back to Chandra, I combined a post from Ram and a post from Chandra because both had similar questions. So he's got till August 2017. My question is my May 2018 still valid? No. Government wants you to look at only the most recently issued I-94. So if it is a government error, I don't know if it is, then you can correct it through CBP. Otherwise, those two options, either apply for an H1 extension like you normally would through USCIS, or go outside USA and come back using the approval that is good till 2018, and they should be able to give you a new I-94. The next question from Ram is somewhat similar, I think. Renewed my passport, L2 visa, like to go to San Diego, Tijuana border. Is it okay to go to San Diego, Tijuana? I don't see why not. You don't have to go to Canada, etc. There's only one little wrinkle that you guys need to be aware of. That wrinkle is this. Normally, when you are going to a contiguous territory, which means joined with the USA, Canada or Mexico, you know how they are landlocked, land joined with USA. And if your trip is less than 30 days, you actually don't even need a visa. It's called automatic visa revalidation, AVR, to re-enter USA in many circumstances. So just make sure before you leave USA, you can ask the CBP, can I surrender my I-94? I have never had any problem. People who didn't even surrender their I-94, when they came back, they just said, we want to re-enter, can you give me a new I-94? People have always been able to get it. So I think that should work fine. *5 if you have a follow-up question on this. *5. People who are still just logging in, guys, we won't have time for new questions. We have enough questions on the roster today. *5 if you have a follow-up question. Okay, let's go on to the next frequently asked question. Okay, these were all the frequently asked questions. Now, in the order posted, let's go back to the regular question. Oh, there is a frequently asked question. One second. Let me go back to the question. I-94. Oh, there's two hands up now. One is from Texas. Texas, go ahead, please. Texas.
Yeah, hi Rajiv.
Hello, sir.
Chandra. Thank you very much for your reply.
Yes, Chandraji.
And I have one follow-up question.
Sure, sure.
You see, you said two options, right? For one is I can go to TPP, I can get new I-94, That is one option. And second one is H1 extension, filing H1 extension, right?
Correct. Yes, sir.
How, if I do H1 extension, I can get one more I-787A. In that I-94, you are saying, which will not updated in online, right? In CBP website.
Yeah, see what happens is when you apply for an extension within the United States, CBP has nothing to do with it.
Mm-hmm.
That
Yeah.
that approval I-797 comes with a new I-94, which is the valid one for you then. Forget about CBP. Whatever USCIS then issues you, that is the operating or the effective I-94. Everything else can be put on the shelf. Okay?
Okay. In the case, actually, what happened recently, my attorney filed my H1 amendment.
Right.
Okay. In that, he gave my I-94.
Mm-hmm.
Yes.
Right.
I-94, that is valid till August 3rd, right?
Right.
September 3rd. So, if I get new I-94, is it okay? We can send these documents to them again, or is there any discrepancy because of
No, you can no, you can have multiple I-94s. That's not a discrepancy. As long as none of your I-94s have expired, I don't even need to look at the entire range of activities that happened. All I need to know is that none of the I-94s has expired and you are moving forward to correct the situation either by traveling out and coming back in or by applying for an extension from USCIS. So don't worry about there being any discrepancy. I don't see any discrepancy.
Yeah, so actually, luckily what I did 2 days back after posting question,
Right.
I contacted CBP. They issued a new I-94. I submitted my I-787. So they corrected and they sent me updated I-94.
Good.
Still valid.
Good. Then you're all set. No problem. Okay.
Okay. So I already filed amendment. I have nothing to do with that, right?
No,
It will be going.
I don't see any problem with it. Okay.
Okay, sir. Thank you.
You're welcome. Good luck. Okay, I think I just put somebody's hand down by mistake. Let me just go to, this one is also from Texas. Let's go to Texas again. 1 second. As soon as I can figure out where I am. Texas. Oh, everybody's hand went down, guys. Press *5 if you have a follow-up question. No new questions. *5. Okay, good. This one is Pennsylvania, one from Pennsylvania, one from Texas. Let's go to Pennsylvania first. Pennsylvania, go ahead, please.
Hi Rajiv, good afternoon. Actually, I raised one question and it's in the FAQ. Sorry, I was little late and I hope you already answered.
Yes, I have already answered all the frequently asked questions.
Okay, I'm sorry.
Yeah.
Can you please?
No, I'm not. No, that's not a good habit. Let's not get into that. I have already answered it. You will get a recording by the end of the day tomorrow. Okay.
Alright, Rajiv, I will listen to that, and if I have any question,
Yeah, we can talk again. No problem. Good luck.
Oh, thank you very much.
You're
Bye.
welcome. Bye. Okay. Guys, we are a little pushed for time. I have to cover a lot of ground, so I can't really indulge everybody. Sorry about that. Okay, let's go to... This one is Texas. Texas, go ahead, please. Texas.
Yeah, Rajiv, this is deep, this previous question you were talking about. So, I went to the, border state. I didn't go to Mexico. I was in the US only.
Right.
And CBP in Laredo, Texas border. They have given me a new I-94.
Okay, that's...
Without crossing the state.
That's very
So
good. That's very good.
Yeah.
That's very good.
Yeah. When I saw online, I can see the new I-94. They have taken the I-94 number from my petition. They have updated online. So I can...
That's very good. I mean, that's something I hadn't heard before, because normally the procedure is you step outside and step back in, but if at the border they can give you an I-94 without you crossing over, that's even better. That's perfect.
Yeah.
Good to
But
know.
only thing I I can see all the things correctly, like my I-94 and proper passport line visa expiry date. But when I see the arrival departure record, it's showing 2 arrival, but no departure in between because I didn't cross the border and I get to I-94.
I think you're okay. I don't see any problem with that.
Okay. Thank you, Doctor.
You're
Thank you so
welcome.
much.
Good luck. Okay. Let us go on to our regular questions. Starting from, let's see, from Jamila. Jamila says, born citizen of the United States, at the age of 16, I was kidnapped by my family into the Middle East. I was forced into an arranged marriage. Then my husband came to USA. Took me a while to break free from him and the unfixable trauma and psychological damage. I'm still legally married to that monster. Anyway, he got remarried. Now, Jamila, that's a crime. Bigamy in the United States is a crime. He should go to prison for that. So first thing, if I were you, I would file a police complaint saying that he's legally married to me and now he's also got a second wife. You can't revoke his green card unless, I'm thinking about, the only thing I can think of is, if the marriage that you entered into was before the age of consent. So let's say you got married to him under the local laws, let's say in the Middle East the age was okay, but the state where you moved, that kind of marriage would not be recognized as being with a person who is too young to give consent. You could try to raise that issue and say that that green card should be revoked because it was given based upon a faulty marriage. That's one part. Second part is, of course, if he's legally married twice, he can go to prison on that, and that itself I think will become a ground for rescission of his green card. There are too many variables for me to really comment about that. But those are the two possible approaches that I see. *5 if you are here and you have a follow-up question. *5. Okay. Let's go on to the next one. From Abhi4Help and Rajesh Nala. I combined these questions because they were very similar. So I just want to make sure I covered everything. All of this is okay. I covered this. So let's go to Abhi4Help and Rajesh Nala, who says, Abhi4Help says, I have I-140 approved for employer A in November 2017. Now I joined company B. So you've got your I-140 approved, but you said November 2017? That doesn't make sense. If you mean November 2016, I think I can answer this question. November 2017 must be a typo. So if it has been approved for 180 days and stayed approved, I discussed this issue actually several times. So the scenario is this. I'm working with an employer. They filed my green card. I want to leave them but still process my green card through them. I think there are some common sense issues with that. Theoretically, it's fine. Green card is for a future job. But if you're already working for an employer, questions can be raised. One, is this job given on a permanent basis? Then if it was on permanent basis, why are you leaving? And why is the employer letting you leave? And while you are gone, who will do this job? And the second part is, do you intend to take this job permanently? Because that's the basic underlying principle for green card. Is the employer holding it open for you? Why are they holding it open for you? So these are some of the issues that can arise. But other than that, even if you leave the employer, they can still hold on to your I-140. And when the dates become current, you can file I-485 using the employment offer made by the old employer. But keep in mind these questions. Employer A revokes I-140, then what steps employer B has to take? They have to start your green card all over again. Just because your I-140 was approved and stayed approved for 180 days is not a track for getting a second green card. You have to establish another track. The exception to this rule is when you do I-485 porting, which means your dates became current, your I-140 was approved, you filed I-485, it stayed pending for 180 days. Now you can move and not start the green card all over again. That's AC-21 portability of the green card. This is I-140. This is not I-485. Rajesh says, my I-140 is approved 4 years back. Priority date is September 2012. If I join a new employer and if he does not start the green card processing, can I still extend my H1 with existing I-140? Yes. Why not? Any rough idea when my priority date will become current? No, I can't predict that. Okay, that covers these two sets of questions. *5 if you have a follow-up question. *5. Next question is from there is a question from Massachusetts. Massachusetts, go ahead please.
Yeah, hi Rajesh, this is Rajesh.
Yes sir.
Actually I have one more question.
Okay.
If I join a new employer and after some time I want to come back to the existing employer, can I still use the existing I-140 which has been filed by the current employer?
Yes, I just answered that question. As long as you had the job offered on a permanent basis, the job stayed open, you had the intent to join them back, they had the intent to take you back, all of those things are there, you can go back. Okay?
Oh, okay, yeah. Thank you so much.
You're welcome. Good luck. Okay, so we just did this one. CPOW says, this is my second visit to USA, B1, B2. My boyfriend is on J1. Can I marry him here and change my visa status? Yes, but it is a little tricky in a couple of ways. One is that when you enter USA and within 60 days try to change your status to something else, government can consider that to be fraud or misrepresentation. But either when you obtained the visa stamping in the consulate, you lied and your intention was to stay here for a longer period of time, or when you entered the USA at the airport when they asked you why are you coming in, you lied because your intention was to stay here. So these are some of the things. I would not want you to do this lightly. Please have a one-on-one consultation with the lawyer. Go over the facts of your case. Also discuss with the lawyer whether your boyfriend has a home residency requirement on his J1 visa. And if you were already married and you had your spouse's name on your passport, but if there's a legal divorce, how does that matter? I don't see any problem with that. *5 if you have a follow-up question. *5. Next question is from Vinay's, I don't know how to say this. He's on an H1B visa. He got a citation for an ordinance violation for fireworks, doing fireworks in front of the house. Now the concern is this is going to affect my H1B. Guys, the way, first of all, there are some things you have to remember in crimes or violations. If it is a civil violation, just an administrative violation, for example, you were parked illegally, or you did something which violates the county ordinance without it being a crime, those are minor things. Those don't become a problem. The second set of issues comes in when it is a minor crime, but it is a crime called misdemeanor. Then you have a different set of circumstances. The third is when you have a serious crime. That's a different set of circumstances. By the way, you and I have exchanged emails also, and I remember telling you to talk with a local lawyer because it would be easier for you to, I think it was you, I hope, because I remember this fact pattern. I said, talk with a lawyer in the state where the citation was issued, just to make sure this is not a criminal violation. If it is a criminal violation, then we need to take a different approach. Even then, I would suggest talk with a lawyer who does deportation, etc. in your own state. Because if you talk with a lawyer like me, I can generically tell you the law. But if I have to go and look at the statute, either I need a local lawyer to do it for me, because it's unethical for me to comment about the laws of another state, or we've got to refer you to a lawyer in that state and kind of oversee the immigration aspects while they tell us about so in any case, I'll need a local lawyer, and that might end up costing you more money. So if you have a competent lawyer locally, you can just go talk with them. Star 5 if you have a follow-up question on this. Okay. Kentucky, go ahead please, Kentucky.
Yeah, thanks, Raju Ji, for everything. So yeah, I posted this question before I sent you the email.
So we did. I remember the fact. So I knew I had talked.
Yes.
So
yes, and I went to the court yesterday, and I talked to the prosecutor and the judge, and they told me that this is a city ordinance violation, and they gave me a deferred disposition, meaning like after 30 days, I just have to go back to the court and sign a document, and then the case will be dismissed. And also the prosecutor said, like once the case is dismissed, that means I'm not convicted.
No, stop. Talk to a lawyer, and talk to a lawyer who does both immigration law and criminal law. This is not that simple. Under immigration law, something can be a conviction even though under state law it is not. Yesterday, there was a ruling from the Board of Immigration Appeals that said, and I've said this to people many times, don't take it for granted just because the judge said so or the prosecutor said so. They are not immigration law experts. Immigration law takes a different view. Yesterday there was a ruling that said under Virginia rules, even if there is a deferred adjudication, we consider it to be a conviction. So please take a consultation. Don't just assume it's okay. All right?
Okay, and one last question, Rajuki, and it's just that, when I was before, they also told me that like any speeding violations, no matter if it's like 5 miles per hour or, for that matter, all the speeding violations come under Class C misdemeanors in Texas. So if that's the case, then if we have any speeding ticket in the state of Texas, then should we be concerned because it comes under the misdemeanor?
No, it's more than that. Any misdemeanor anywhere in the country. If you have 2 misdemeanors, you have a different set of problems. So please don't get involved with this. I think you need to talk with a lawyer. Don't just assume that you know the answers. Okay?
Okay, all right. Thank you.
Good luck. Yeah, this is a very complicated area of the law. We've been dealing with it for many years. In some of them in very serious contexts, including corporate crime, etc., alleged corporate crime. So please be very mindful of that. Don't assume you know what's going on. Next normal question is Shankar Somashekhar and Ravik for you. 2 people I combined because the questions were similar. So when do we file H1B amendment? And the answer is whenever there's a change in the job, you always need to file an H1B amendment. The only exceptions are if the job remains the same, job description, salary, etc. remains the same, and the only thing that has changed is some local movement. So if you went from one office of the end client to another office of the end client 20 miles down in the same area, you don't need to do an amendment. Otherwise, you should always do an amendment. What constitutes MSA? Why do you want to get involved with this? Because MSA definitions, I'm not even sure what they are. I just know what MSAs are. So you can go to flcdatacenter.com, Foreign Labor Certification Datacenter.com. Center is CENTER, and you can look at the various wages based upon the county. So flcdatacenter.com. I live in McLean. So McLean, Bethesda, Washington DC, Herndon, it's the same MSA. I think our MSA in the Washington metropolitan area goes all the way to Baltimore almost, and all the way to Loudoun County. Yeah, all of this is Washington DC metro area. You have to file an amendment for the project in New York. What is the difference between LCA, H1 amendment and extension? LCA is a Department of Labor approval. It's given routinely. H1 amendment means there's a change. Extension means you want to extend the time period of your H1. All of them, not the LCA, amendment and extension, involve very similar determination. Government reopens the case and looks at everything all over again. H1 amendment involves both LCA and an amendment. Cost is less if you do it without extension. Well, if you do an H1 extension, and even if your I-94 expires, you can continue working for up to 240 days. You should be, I think so, you should be in the USA when the extension is applied or amendment is applied, but after that you can leave if you already have a visa stamping. You're not required to be present in USA during amendments. I think when they file, you have to be in USA, that's my impression, but once you leave USA, once it's been filed, you can leave USA. This is true for extensions, amendments, as well as transfers. Has there been any changes in H1B since 2017 pertaining to H1B worker working for two employers? No. Same law for concurrent H1s, no difference. Next set of questions from Ravik for you. My project is going to complete being assigned to a new client location. Should LCA be approved or filed before starting the new client? You have to get the amendment filed. LCA should be approved, paper should be sent to USCIS, and then you can change your jobs. What if I do not have permanent residence to new location for initial couple of months? I think that's okay. I'm not sure I can really make comments about your permanent residence. I'm not sure what you're thinking. If you're on the phone or any follow-up questions on this, press *5. Let me understand what you're saying. *5. Okay. No follow-up questions. Okay. So normal rule is, look, the job location, if you're working from home occasionally and casually, it's okay. But if you make your home office your permanent place of work or predominant place of work, LCA should cover that as well. And your lawyers can do that. They can cover the two locations. Make it clear that first couple of months you're still going to work from home while you're looking for a place in the new place, the new employment location. Okay. Let's go on to the next one. This is from Samir. Conditional green card 751 along with other related questions. Can I take extended emergency and unemployment benefits? I believe so. Why not? Because as far as I understand, unemployment benefits are a part of your private insurance, whether your employer pays for it or you pay for it. Private insurance has no impact on government funding. It's not coming from the government. Will it have any impact on naturalization? Look, the only money that you receive from the government that is considered to be means tested benefits coming from the government is objectionable. But if money is coming from private sources or it is not a means tested benefit, means tested means it depends upon how much money you make. So I can't really comment in the abstract, but you have to look at these two things. Is the money coming from private sources like an insurance company, or even if the state government is giving you the money, is it pursuant to a insurance that the employer pays into? I'm not a benefits expert, so you have to check into that. If I resided at more than one place after getting my green card, do I have to mention the address? I always tend to go towards, I can't help you fill forms, but I can tell you this, that my inclination is always to over disclose rather than keep information back. Oh, you already know about means tested benefits. Very well, very, very good. So if I'm trying to get federal training, Workforce Innovation and Opportunity Act, I hope it should be okay. I don't know about this law. But if it is not a means tested benefit, of course it's okay. I'm in the process of filing for 751, sponsor my parents on a visitor visa. I don't see any reason why not. I don't see any reason why not. Does reinstatement of I-130 for a relative compared to MTR guarantee the original priority date? Yes. When you do an MTR and if it is successful, you will keep your priority date. MTR is a motion to reopen. I'm not sure what you're asking, but reinstatement of I-130 petition, I don't know of anything that's called reinstatement. I think MTR is the only choice. If you are talking about humanitarian basis reinstatement where somebody died, that's a different situation altogether. Of course, in those cases also, the beneficiary keeps their priority date. But MTR, if it is granted, you keep your priority date. I don't think there is anything as reinstatement of I-130 in normal cases. Star 5, if you are here, Samir. Star 5, if there's a follow-up question. Yes, sir, go ahead. I can hear you.
Thanks for taking the call.
Sure.
Regarding the first question, the extended unemployment benefits, as far as my understanding goes, a portion of the unemployment insurance of the unemployment benefits is paid by the previous employer and a portion is paid by the government. As far as my knowledge or my understanding.
1 second. I can't really comment on that. Like I said, there are so many local variations to these themes. I don't want to misguide you. I have no idea what these benefits are, but these are the things that you should look at. You already know what you should look at. Talk with a benefits lawyer.
Okay, Rajesh. Okay, sure. And one more thing. Since I'm in the process of filing I-751, so no issues sponsoring for parents on it.
Yeah, I don't see any problem.
Because the GC is going to expand in probably in next 2.5 months or so.
Yeah, but when you file for 751, your green card is extended automatically. I don't see that as a problem.
Okay. And one last question regarding question number 5 is primarily besides reinstatement, this is for some other petition. One of my other sibling for filed by another US citizen sibling. So the question is that there's something called as EOIR, right? Rajiji, EOIR 29.
Executive Office for Immigration Review. Are you talking about an appeal to the Board of Immigration Appeals, BIA?
Yeah, yes, exactly. Something similar to that.
Yeah. You see, between an MTR and an appeal is better. Okay.
I believe appeal has to be filed within the 30 days time frame, right? So the I-130 denial has taken long time back actually.
That's a very complicated situation. I can't comment in 15 minutes or 5 minutes that we have. Sorry.
Sure. Okay, sure.
All right.
Thanks for.
You're welcome. Good luck. Yeah, sometimes you can reinstate some very old cases. We had a case we got reinstated. It was a PERM filing 2.5 years later after it had been dismissed. Because what happened was the lawyer who was representing this lady, she was a nurse. The lawyer just went absent. He just folded up his business and left. So he didn't respond to a notice from the Department of Labor, which was actually a very minor thing, because of which the case got dismissed. She accrued unlawful presence. It became a big problem. So we were able to get that case reinstated even though it had been declined and dismissed for 2.5 years. So it depends upon the case. It's usually not easy to get these cases reinstated if they've been closed for a long time. Okay. Next question. Let's see. So this one is from Deep. When I extended my L1, I got I-94 with full validity. Then I went to India, got my visa for full validity. I should have combined this. Then I returned, I got a new I-94 with validity only till the passport expiration date. Then I renewed my passport, went to Laredo, Texas, didn't cross. They gave me a new I-94. I think you were on the phone, weren't you? Just a minute ago. So it's showing my I-94 with full validity, very good. So I got I-94 original petition last year at the airport. All of this is okay, we already talked about it, Deepji. I'm showing 2 arrivals and only 1, but no departure. I don't see any problem with that. Because you went to the border and you got this corrected, I think your job is done. When I will extend my visa, I haven't researched this issue specifically, but you know what? If you are still concerned about it, you can always have your congressman's office follow this up for you. They can usually get you good information. Just say, this is what happened, is this okay, is this normal? And please do shoot me an email if it is not normal. Okay? *5, if you have a follow-up question on this, *5. Okay, so we are moving into the last, oh my God, we have a lot of questions still left. We went over a little bit. I'll do my best to just finish it up. Hari 27, my H1B expires August 3rd, 2017. I'm planning to change of status to H4. Wife's H1 expiry November 2017. If I find work during the change of status, can I change again to H1? Probably not. Because, and we've discussed this before, if you are in between statuses, then you are in authorized period of stay. You'll have to go out for visa stamping, but you can apply for H1. If COS decision is not yet made by the time of my wife's H1 expiration, can I apply for H4 extension? Yes, you can file for an H4 extension even while the current one is still in process. No problem there. *5 for a follow-up question. Okay. Rahul Gopal Joshi, he's an old friend of ours. Can the job description, candidate requirements as submitted by PWD and the ones used for actual recruitment be slightly different? Very difficult question to answer. It depends upon the PERM language. Very, very difficult question to answer. I like to keep them the same. Can't really answer these questions. They are so tightly fact-bound. Normally, let me tell you the generic rule. Generic rule is, if there are 2 companies, one is not doing business with the other, and that you are not employed, let's say you have the employer and the end client. If you are at the end client and the end client hires you, you can't use the experience gained with that while working as a contractor for the end client. You have to have a different job. But if there are 2 companies and you have not worked one from the other, you can use the experience gained with one while working with the other or applying for a green card with the other. That's not a problem. So once again, if the end client hires you, you can't use the experience gained while working as a contractor. But if there are 2 separate companies, separate tax IDs, even if they are working from the same premises, same ownership, no problem. As long as they are separate tax IDs, you can use the experience. Next question, just press *5 if you have a follow-up question. Calm I-140 says, how do I get a copy of my I-140? You apply for Freedom of Information Act request with the government. There's a form for it. I think it's G639 if I'm not wrong. Go to the USCIS website, look at the forms, and there's a form for Freedom of Information Act request. File it. It doesn't cost you any money. Most people have been able to get their I-140s this way. Next question, Raja 1234. L1B for Company A. Company A filed H1B under consular petition. Got selected. Yes, you'll have to go to your home country for visa stamping. If you want to do a change of status, it's just like filing a new case. Lesser fees, but they can reopen the whole case. And the time it takes is pretty much the same as it takes to get the new H1B approval. I don't know the answer to what is better, extend L1B or go to H1B. That's your lawyer's job. They have to look at your case, assess the relative value and see which case works better for you, which case has more merit. Can't really comment. But yeah, filing a change of status, H1B change of status is just like filing a new case all over again. Lesser fees, of course. Shankar ZX says, I want to check with you on my H1 RFE. Okay, one second. There's a follow-up question from California. California, go ahead, please. Yes, sir. Go ahead.
There is no option for here to apply for change of status.
No, change of, see, hang on. Change of status for other people is I-539, simple form. Change of status for H1, L1, etc. is I-129. The same form we use to apply for a new H1, L1, a transfer to a new employer, an amendment, an extension. Change of status takes the same paperwork all over again. Okay?
In that case, they will not have like in the sense, how much time they will take?
It's gonna take, it usually takes the same amount of time. I'm not aware of any difference in times. Takes the same amount of time as a new case. Okay?
So they will not stop my random, already my H1 is selected. So
Sir, you're asking me the same question in different language. The answer is still the same. Okay? So let's just take that for granted. There's no other way to do it except for doing a change of status, and that's just like doing a new H1 all over again. Good luck.
Thank you so much.
You're welcome. Okay, now I don't blame you. Sometimes you need to ask the same question in different language, but it is the same question. Okay, so Shankar ZX, want to check in on an H1 RFE. Due date to respond was July 1st. Okay, I don't want to comment about the exact circumstances of your case. The way it works is, this is how you calculate. If the last date of response for an RFE or any other matter, filing for appeal, falls on a federal holiday, like a weekend or Veterans Day, your deadline is automatically extended to the next working day. So if there are 3 holidays, Saturday, Sunday and Monday, your deadline, if it falls on Saturday or Sunday or Monday, will be Tuesday. That's the way it works. *5 if you have a follow-up question. *5. Okay. Anne says, I'm planning to enroll for school this fall, initiating H1B to F1 change of status, and the change of status effective date will be within 30 days prior to start date. My H1 will be expiring soon, hence we'll be filing the petition before visa expiry to be considered as timely filed. I just got to know from DSO, until my F1 is approved, I can attend classes. This is true. However, they will defer the date. I don't know how they do that. I know there is a deferment procedure. I've seen it being done. I'm not exactly sure how they do that. That's something only your DSO can tell you. They'll defer the date on the I-20, extending it every 15 days. The change of status can take 90 days to 6 months. Since I will not be on H1B after my visa expiration on August 7th, I'll be quitting my job. I'm worried deferring of this date will make me go out of status. And I'm not sure how to handle this situation. I typically, if I were in this situation, I would want to know. I don't know how this process of deferment works. I think what you're talking about is there must not be a gap of more than 30 days between the date your status expires and your F1 begins. So once you file the H1, they keep deferring dates. They know best in this particular area. I don't have a comment unless I speak with the DSO and find out more about what they're planning to do. You can have your lawyers call them, and if this process works, great. You can even call SEVIP. Ask SEVIP people if they talk with individuals. You can ask them if this process will work for you. I really don't know. I've seen it happen. I don't have any personal experience how far you can carry it. since we don't get involved with the inside workings of a DSO's office, so it doesn't come to us very frequently. Star 5 if you have a follow-up question, guys. Star 5. Okay, let's take this one. This one is from Minnesota. Yes, Minnesota, go ahead, please.
Hi Rajiv sir, can you hear me?
I can hear you fine, ma'am.
Yeah, thanks for your response. I spoke with my DSO. What he mentioned is this is a rule to defer the day. As per the rule, he has to keep deferring until my F1 kicks in. So he said that I will still not go out of status because in that case I will be considered as in pending status. So
I can believe that because I've seen it done, but I don't have any personal experience with it because there are two components to this. One is completely internal to the DSO's office. There are a couple of things you can do. You can actually call USCIS, ask to speak with an adjudications officer because you have a very unique question, and run this scenario by them. Okay, call USCIS.
So does the USCIS be entertaining such questions?
They actually do. Surprisingly, when the question is complicated and you sound like somebody who can ask a well-articulated question. When you have a question like this, the frontline staff will typically transfer you to the adjudications officers, and these guys do this for a living. In fact, our office calls them too in cases where some procedures or logistics are not clear. We end up calling them. You could do that. You could confirm that with them. Okay. Call SEVIP also. Yeah, you can do both things.
Yeah, because I've seen cases where
I have too.
Status change from B1.
Yeah, I have seen it too, but I don't know how they do it. I don't know the logistics because we don't get involved with those things. We come in once you step out of school. Okay. All right.
So in case if worst case scenario, if say USCIS declines my F1, so that 6 months will I be considered out of status? Like I will have to depart immediately. So will there be consequences if I come back as an F1 again?
Out of status doesn't bother me. Unlawful presence does. As long as you have a timely filed case, I don't think you can accrue unlawful presence even if you wanted to. So being out of status can be an issue for F1. It certainly is not an issue for H1. And when you have a good explanation why you are out of status, it should not be an issue even for an F1.
Okay.
Okay.
So in that case, I think I'll just call the USCIS and I'm just gonna take a risk of applying it because
look into that.
I will be anyways timely filing.
Look into that, and you could also ask the DSO if there is a need for you to get a lawyer involved in this, because I'm not sure that we can do anything more than what the DSO is doing. If this process is normally accepted by the USCIS, you are good to go. Okay.
Yeah, because the DSO is confident about it, and he said he has seen these kind of cases, which is.
Yeah, I have to. In fact, just a few weeks ago, I think 3 or 4 weeks ago, we had a very similar situation, and that worked out okay. So I don't know if this was exactly the same set of facts, but it looked okay to me. Double check it. Call USCIS, call SEVIP, but USCIS will be able to answer your question. And if you find out what they say and it works for you, just drop me an email if you can to help@immigration.com.
Sure.
Okay.
Yes, sure. I will keep you posted on these updates because I have done a lot of research, spending a lot of time, and I haven't got an answer yet. So I think this will help if I get an answer to many other people who.
Right. We'll spread the information to the community as we talk to people. No problem at all. Okay.
Yeah. Sure.
Thank you.
Thank you, sir. Thank you.
You're welcome. Bye-bye. So there is one more hand up. Not sure what that is about. This was my last question. Okay, let's see. This one is from Florida. Florida, go ahead, please. How can I help you?
Yeah, hi, Rajiv. This is a follow-up question to the number 15 question. Change of status from H1 to H4. If I heard you correctly, you told that I can apply for H1B again during the change of status?
Yes. The only problem is,
Okay, so-
the only problem is,
Yes.
if on the date they adjudicate your H1, your H4 is not already decided in your favor, they'll approve the H1 but make you go outside for visa stamping. You can go to any country, including Canada or Mexico, and get your H1 visa stamping.
Okay. Okay, but can I start working when I get the receipt number for the H1, or I need to?
You cannot.
Approve?
You cannot. You cannot start working.
Even if the I-94 date is not yet expired on the previous H1, still
I will have your lawyer look at it. I don't think you can. There is a little bit of a gray area there. Can't really comment about it without knowing all the facts. I would, if I were you, I would ask my lawyers and preferably get something in writing.
Oh, okay.
All right.
Thank you for your.
You're welcome. Good luck. All right, folks. As always, I feel very privileged to talk with all of you. We'll talk again in 2 weeks. I wish we had more time for these conversations, but this is all we can do. So talk to you again in 2 weeks. Good luck. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.